Good afternoon and welcome. We're pleased to welcome all of you, and we are thrilled to be back in the courtroom. It's been a long absence, and it's wonderful to be in your presence in this distinguished hall. We will call the cases in the order in which they appear on the docket. Each side, each appellant and appellee each have 15 minutes, and the appellant may reserve up to 5 of the 15 minutes for rebuttal. Unless there are any announcements, I'll ask the clerk to call the case.
Jeffrey Polhamus versus State of Tennessee.
All right. We're prepared to hear from the appellant. Good afternoon.
Good afternoon. May it please the court, Amanda Jordan on behalf of the defendant in the state of Tennessee, and I would like to reserve 3 minutes for rebuttal.
Certainly.
Thank you. The state asks that the circuit court's order denying the state's motion for summary judgment be reversed because plaintiff cannot establish an essential element of his claim, that the state owed no duty of care to the plaintiff. Now, this case arises from a motor vehicle accident on West Stone Drive and Lynn Garden Drive within the city limits of Kingsport. The plaintiff alleges that as he was entering the on-ramp onto Lynn Garden Drive, that he encountered a rough patch of the road that caused him to lose control and be thrown from his motorcycle. The state is entitled to summary judgment because by virtue of a contract between the state and the city of Kingsport, the city of Kingsport had the responsibility for the maintenance of this subject roadway where the accident occurred. Therefore, the state no longer owed a duty to the plaintiff. Now, pursuant to Tennessee Code annotated sections 54-5-201 and 203, if a municipality is organized for the care of its own streets, such as the city of Kingsport here, the state may enter into maintenance agreements with the municipality for the construction, reconstruction, improvement, and maintenance of state roadways within the municipality's city limits. Here, these roadways are state roadways within the city limits of Kingsport, and at the time of the plaintiff's accident, the city and state had a maintenance agreement for these subject roadways. And under the contract, the city of Kingsport was responsible for doing the maintenance and would then be reimbursed by the state. And the parties specifically agreed that the Department of Transportation is not assuming any liability for damages caused to any person or property by reason of the city's performance of this contract. Therefore, the contract not only delegated responsibility for the maintenance, but it also delegated liability to the city under this contract. But when ruling on the motions for summary judgment in this case, the circuit court found that the city of Kingsport was immune under the Governmental Tort Liability Act because immunity is only removed for defective, unsafe, or dangerous conditions on any street owned and controlled by the governmental entity. And here, these roadways are actually owned by the state. But even though the city of Kingsport may be immune under the Governmental Tort Liability Act, the state, having delegated maintenance responsibility to the city of Kingsport, is also immune under the Claims Commission Act.
Well, how can both entities both be immune in an action like this? Or how can there not be a party that has a duty?
So, as both governmental entities here, they have sovereign immunity. And unfortunately, this is just an instance in which neither entity has consented to be sued in an incident such as this.
That's not necessarily the case, is it? The consent to sue has been removed, is there, except for the contract in this case. You're saying that the state does not have an obligation. But isn't that like the state saying, I'm going to let the city or some other agency do the work, maintain the work, but they still have an obligation, don't they?
Since this delegation is pursuant to statute, it is not such non-delegable duty such as that. So the state is shifting that entire duty to the city of Kingsport here, and the state no longer had a duty for the maintenance.
So what about the city then? Does the city take care of the obligation for the maintenance? I mean, they do have an obligation for the maintenance, but what about the liability part of it? The city don't have that?
The city would have the liability if it owned this roadway. So this instance here, where the state actually owns the roadway, I think is the exception where there is no liability. Because the designation of a road as a state highway does not necessarily mean that it's state-owned highway. So ordinarily, these roads...
Doing the maintenance themselves, will they have liability?
Yes, under 98307 A1I or J, the state can be responsible and have liability for negligent maintenance of state maintained highways or state roads that are designated as being part of the state system of highways. But it also says in the Claims Commission Act that the state is only liable for the negligent acts or omissions of its employees.
Okay, so the state can delegate the responsibilities for the maintenance, but it cannot delegate the responsibility for the liability, is what you're saying?
No, I'm saying in this case, because the legislator specifically authorizes the state to delegate the responsibility for the maintenance to the cities through these maintenance agreements, that the state can therefore delegate the maintenance and the liability. It's just in this limited circumstance here, where the roadway is owned by the state, that neither the state nor the city has consented to be sued in an instance such as this.
Okay.
Please proceed.
And when you're looking at waiving sovereign immunity, you have to look at the actual words within that statute, and the courts are not allowed to broaden it beyond the scope of the legislation. And as I mentioned a second ago, that under the Claims Commission Act, the state is only liable for the negligent acts or omissions of state employees. And the definition of state employee does not include persons employed on a contractual or percentage basis. And this maintenance agreement between the state and the city of Kingsport explicitly stated that the parties are independent contracting entities and that nothing in that contract should be construed to create an employer-employee relationship. Therefore, under the plain language of the Claims Commission Act, the state cannot be liable to the plaintiff in this matter because the work was done by an independent contractor and not a state employee.
But doesn't the state still own and control the highway? And it has only delegated the responsibility to maintain it to the city, but doesn't the state still own and control the city's maintenance of the highway?
The state's position is that it delegated all responsibility for the maintenance of that roadway. So based on the language of the statute, I think the state would still be responsible for any construction or reconstruction, but in terms of general maintenance, all of that responsibility and liability had been delegated to the city of Kingsport.
Would not the state have a cause of action against the city if it's determined that the city failed to maintain the highway in accordance with the contract, and as a result, the state was held liable for an injury to someone such as this plaintiff?
Only if there's a specific provision for that under the Governmental Tort Liability Act, because the contract actually points out that since these are both governmental entities, that any kind of indemnification provision runs afoul of sovereign immunity since it's not authorized by the General Assembly.
Thank you.
Now, the Circuit Court and plaintiff also contend that a ruling finding both the city of Kingsport and the state immune from suit would be against public policy. But the contract cannot be against public policy when that delegation is specifically authorized by statute. Both statutes authorizing the state to enter into maintenance agreements with municipalities such as the city of Kingsport were in effect when the legislator enacted the Claims Commission Act in 1985. So we're to presume that when the legislator abrogated the state's sovereign immunity for negligent maintenance of highways, it did so with the knowledge that the state was also authorized to contract with municipalities for the maintenance of such streets.
Does the contract itself says who is responsible for failure to maintain the highways?
It does not, Your Honor. The only provision that is in the contract that deals with liability is the provision that states that TDOT is not assuming any liability under the contract. And I believe that's paragraph D13 of the contract.
Is there anything in the contract that says TDOT or the state waive any responsibilities?
No, Your Honor.
So the situation then that is presented would create a wrong without a remedy, wouldn't it?
It would, Your Honor, but that limiting the causes of actions that one could bring is not necessarily in and of itself against public policy, because like we have here, the legislator specifically allowed for this type of delegation. So it's the state's position that this contract is not against public policy and would therefore be enforceable to shift responsibility as well as liability onto the city of Kingsport. And for that reason, the state had no duty of care to the plaintiff in this case. So to conclude, the state asked this court to reverse the circuit court's order denying the state's motion for summary judgment and remanding it back with instructions for the court to enter judgment against the state in this matter, because the plaintiff has not proven an essential element of his claim that the state owed a duty to the plaintiff. Thank you, Your Honors.
All right, thank you, General. We'll hear from you further on rebuttal. We'll now hear from the appellee. Good afternoon.
Good afternoon, sir. I'm Jack Vaughn from the Sullivan County Bar. I would respectfully disagree with many of the arguments that the state puts forward. First of all, she said the state claims that there is no, the city cannot establish why a reason for summary judgment should not be granted. That's incorrect. The state, in its argument in that regard, in its brief, relied very heavily on an affidavit by Jimmy Church, who was a high muckety-muck in the transportation department, and his affidavit was to explain what the state had done. There is no mention in that affidavit about inspection or visitation. Therefore, we must assume that the state did not inspect or visit the site. Therefore, if they didn't do that, they cannot claim constructive notice. They can't claim that. And if they can't claim that, then notice is an issue. So that would mean that regardless of what is said, this should be
I apologize. I didn't follow the logic you were making. The state cannot claim knowledge or notice. Explain that further.
The state is trying to show notice. And
notice to the city or?
Notice, yes. To get away from the summary judgment, to defeat the motion for summary judgment. And because their notice, the only proof they have on notice, since they'd never been out there, would be
Is that an issue considered by the trial judge?
Pardon, sir?
Was notice an issue considered by the trial judge?
No, but the state talked about that in their complaint, in their brief, and so I thought that we may bring that up. That in fact that there is the state had no notice. They can't rely on constructive notice because they never were out there.
For some reason or another, this does not appear to be an issue, a novel issue here. Is it an issue by first impression or what?
No, sir. The state said that the city could not establish reasons why the summary judgment should not be granted. And I'm simply saying that the state itself can establish notice, which is a ground for their receiving the summary judgment. And without having gone to the site and visited, they can't use constructive notice because they never were out there. They don't know what's out there, before or after. Now,
Did the contract address responsibility or liability between the state and the city?
it does, but our theory is that the contract is void by reason of being against public policy. The statute granting the state rights to contract with other parties, in this case, to contract with the city to relieve the state of liability. They can do that by statute. I agree with that. But the statute that prevents the city from doing it is directly on point. It controls and owns and controls the subject property. There's no ifs, ands, or buts about it. If they don't own or control it, their immunity is still on. They can't waive that immunity per the statute.
They being the city or the state?
I'm sorry. The city cannot waive its immunity. So that kind of explains why the state's saying they've got the statutory right to do it, and we're saying yes they do, but when they do that and make a contract, they've got to fall within the parameters of public policy. And their policy doesn't fall within the parameters of public policy.
So, and which part of public policy is being violated here?
The being against the rights of the plaintiff to file a lawsuit, at least have a hearing or trial on his claim about being injured.
Against the city or against the state? Which one? Which one?
Against the state, because if my argument is correct, and the case law seems to show that, then the state can contract, but if the contract is unenforceable, then it's null and void. As Professor Overton at the University of Tennessee School of Law says, if it's void ab initio. And if the contract is void, it's void.
And what part of the contract violates public policy? Which
presenting a situation where a citizen of the state of Tennessee cannot recover from either the city or the state, the two only people responsible, could be responsible for this accident.
But isn't this contract silent on that point, other than the legal ruminations of you go around here in this statute and own and control? You have to go through those things to get to the result where we are today.
I can't speak to that because I don't recall, but the point being made is that if it's illegal or against public policy, there's not a contract, and therefore the state can't get out because they have no basis to get out of it, because the contract that they made with the city is null and void, and against public policy. And the case law seems to present that.
Did you find any other reported decisions that address this scenario? As Judge McClarty mentioned, surely this isn't a case of first impression where a city and a state were sued and there was a contract saying that the city will be responsible for maintaining.
No, sir, you're right, but it's nothing clearly on point. It seems to be a first impression thing. I was kind of surprised when I got into it because I figured, goodness gracious, with this simple of a liability issue, that it would have appeared in front of a court somewhere many times, but couldn't find it. There's a The Gutermont case in 1993 says that you can sue the state. And in the Stewart case, clarifies that the Claims Commission Act was to be liberally construed as it was a remedial statute to protect the public. And in this case, the injured party is not protected. And that was after the 1985 amendment to the Claims Commission Act, and it changed the Claims Commission Act. The amendment changed the Claims Commission from strictly construed to liberally construed. There's also the Wright brothers case. It's a slip opinion in 2015. And a construction company bid to move dirt from one location to another. And the location they were going to move to was kind of a wetland. And after the contract was signed, a state entity declared the wetlands to be a stream. Therefore, they couldn't dump dirt on it. Thus, the contractor incurred some pretty serious cost increase. And at that point, the Claims Commission stated that, the slip opinion, the Wright brothers case, said that the Claims Commission Act was a remedial statute to be liberally construed, and is to be construed most favorably in light of the petitioner, in this case, the appellee. Thus, the contract in the Wright brothers case is unenforceable, as it did not protect the public and was against public policy. And here, the appellee is not protected either because he's out in the cold. The two cases that the state claims are one's a Minnesota case and one's a Texas case. And in both cases, no one was left in the cold. No one was left without a remedy, someone to sue. So arguably, that's not on point. The Blackburn Court defined what will be unenforceable, and it stated that a contract will be deemed unenforceable as against public policy if it tends to harm the public good or conflict with Tennessee Constitution, laws, or judicial decisions. And based on that, we say that it is unconstitutional. The contract between the city and the state is unenforceable. In contract to.
Well, the issue in this case is not whether or not the contract is enforceable or not. It's whether or not a party, an injured party, has a right of action against the city who maintains the roadway, or against the state whose obligation it is to maintain the roadway. But however, they have a center obligation or a contract that obligation to the city.
Right.
But the contract itself is just,
no, it's not. I'm probably.
I'm just talking here.
Right, yes, sir.
But the question is whether or not that obligation to reimburse for injury for loss as a result of the failure to perform that contract, who that falls on.
Again, I initially stated that the state was operating under the statute that allows them to contract, and the city is controlled, its liability is controlled by the Governmental Tort Liability Act, which clearly states that unless it owns and controls the subject matter, i.e. this road, it can't be sued because its immunity is not done away with. But each individual contract that the state makes under their statute they're claiming has got to be looked at to see whether is it a good contract or is it an unenforceable contract. And in this instance, it is our position that it is an unenforceable contract, and therefore the state can't get out can't dodge its responsibility. Does that answer your? It's the best I can do.
That's the way.
Bless your heart. It's I'm surprised that Chancellor Frierson, I knew him mostly as a chancellor, hasn't said something to me and raised Cain with me about something.
He's getting warmed up.
Listen, I believe that. But the bottom line is that this young man deserves a shot at getting compensated. And the case law and that I have seen is my interpretation that that yields an unenforceable contract, which allows the young man to sue the state, because the city is immune via a particular specific statute.
All right. Anything further?
No, sir. Thank
All right.
you for listening.
Thank you. Thank you very much.
Appreciate your time.
We'll hear from General Jordan on rebuttal.
Thank you, Your Honors. I would just like to respond to a question by Judge McClarty about whether or not this is a novel issue. And I agree. I've researched it, and which is why I ended up citing cases from Minnesota and Texas for the proposition that such a maintenance contract like this not only delegates the responsibility, but also the liability for performance under the contract. Because there did not appear to be any cases in Tennessee actually interpreting this issue where you have this maintenance agreement between the city and the state. So,
Excuse me.
Sorry, go ahead.
Thank you. General, is this contract in the nature of an indemnity contract?
no, Your Honor, because as I mentioned earlier, it specifically provides that they can't have such an indemnification provision because it will run afoul of the city's sovereign immunity unless there is a specific portion in the GTLA that allows the state to make a claim against the city for a breach of contract or something.
Does the contract address that in any respect?
Yes, Your Honor. It's, believe it is paragraph D12 of the contract that specifically notes that, where it also notes that any liability against the city is also going to be governed under the Governmental Tort Liability Act, and it is paragraph D12, which is record page 34.
But the Governmental Tort Liability Act says that the state waives immunity for injuries occurring on a highway owned and controlled by the state. And in this case, the state owns and controls the highway. It just also entered into a contract for the city to maintain it. And
Yes.
I don't see anything in the statute that says, and the city can excuse itself from liability by doing that, where the statute says that the sovereign immunity is waived.
So under the GTLA, the city would be liable if it owned and controlled the roadway. So the issue here is the fact that the state owned the roadway. But I believe in a different case where we have the same maintenance agreement and the road is just designated as a state highway and not owned by the state, then I think the city could still be held liable under the GTLA because ownership and control of that state designated highway would still rest with that municipality.
So are you saying that the state does not own the highway? I thought the question was the state doesn't control it.
So the statutes in the Claims Commission Act do not reference ownership. They only reference whether the roadway is designated as being on the state system of highways, and then subsection J reference a state-maintained highway.
And this one is designated as a state highway?
Yes, they are, Your Honor.
So the question is limited to control?
No, I think ownership is still always at case 2 because the designation of a state highway does not not necessarily equate to ownership. And I think the cases, it's Collier v. Baker. I'll give you a citation.
Well, if the state doesn't own the highway, how do they have the right to enter to a contract for somebody else to maintain it?
Because the state has the authority over those roads that are designated as being on the state system of highways.
But that doesn't equate to ownership.
Not necessarily. So Collier v. Baker is a Tennessee Supreme Court case that's 27 Southwest 2nd, 1085. Brymer v. Municipality of Jefferson City, which is 216 Southwest 2nd, 1. And then Temple v. City of Clarksville, it's an unreported case, but the Westlaw citation is 1986, Westlaw 7084. I believe all stand for this proposition that even if the highway is designated as being on a state system of highways, it does not necessarily mean that it's state-owned highway and that the city street would therefore convert to being a state highway. It would retain its status as a city street.
That begs the question, who owns the property? Who owns the highway?
Well, in this case, the state admitted to owning this particular
Well, that's what I
roadway.
thought, so why are we talking about that? That's what, I thought the state had admitted that it owns it, and that's why I was trying to get us past that point.
Sorry, Your Honor, I misunderstood. I was talking about how this situation here is probably the exception and
No,
not
no,
always the case under these
This is not an
contracts.
exception if the state has admitted that it owns the highway. This is not an exception.
Right, but it's that admission that the state owns the highway is the reason why the city has immunity under the GTLA, because for them to waive their immunity, there has to be ownership and control.
Okay, but I still stand for the proposition that it's undisputed that the state owns this part of the highway. Thus, the question is, did the state still control it, or did the state abandon its control by entering into a contract with the city?
The control also went with the maintenance, which was part of the contract with the city.
All right,
Thank you, Your Honor.
thank you, Jim.
Maintenance and control equals the same thing. Maintenance is control, that's what you're saying.
If you're just looking at maintenance, yes, the state still would have had the ability to do large construction and reconstruction projects, but in terms of control over maintenance aspects, that lied with the city pursuant to this contract.
So the question is control. Okay, thank you.
Thank you, Your Honors.
All right. We'll give council a moment to step aside from the table, and we'll call the next case.